Good afternoon to all of you tuning in on the East Coast, and really glad to have all of you wherever you are signing in from. We have a great program ahead today. This is our first in March, and if Kathy, you would go to the next slide, please, I'll walk everyone through what we intend to cover. In a moment, I will turn to Phil Zacchio, who is co-chair of our higher education practice and familiar to many of you. He's presented on the webinar numerous times previously. And he's going to cover potential implications of anti-hazing legislation that's percolating at the federal level. Jessica Copeland, who leads our cybersecurity and data privacy practice out of our Buffalo office, will be on next, and she'll be covering fairness implications in AI model training. Thereafter, Lauren Schnitzer, with us from our Melville office, will be covering federal HHS and its recent release of guidance on new sex-based definitions. Mario Ayub, also with Buffalo or from Buffalo, will be addressing parental consent requirements for online education services. And I will try to tie everything together, including answering your questions, 30 minutes from now. So without further ado, I want to bring Phil on. Phil, as I mentioned, is with us from Syracuse, a regular on this program, and we're delighted to have him back. This is a topic he's been looking forward to presenting for this group for some time. So Phil, we're really glad to have you. Thank you so much. The floor is yours.
Okay, thank you very much, Gabe, and good afternoon, everybody. We are going to talk briefly about the Federal Stop Campus Hazing Act. This was a law that was signed and into law by President Biden on December 23rd of last year. And it consists of amendments to the Clery Act. And Kathy, you can bump the next slide, please. The Clery Act is a federal law, and any of you with higher education institutions will be familiar with it. Others may have encountered it. It's designed to do a couple of things. Primarily, it's designed to make information available to the public about the safety environment on particular college and university campuses. It also requires colleges and universities to adopt some specific safety policies and procedures. Kath, next slide, please. The Act contains a definition of hazing, and the thing to be aware of here is that state laws and institutional policies often have their own definitions of hazing. The one that you see on the screen is the one that applies for purposes of the federal law. And one of the things that institutions are going to want to do is to ensure that their own policies are drafted broadly enough to capture the behavior that's described here within their own definition of hazing. Because if they don't, as we'll see in a moment, that may have implications as to whether they're capturing the right data in terms of reporting and responses. As you can see, the definition is a fairly broad one. It applies to behavior that's committed in the course of association with a particular student organization, and that creates physical or psychological injury or a risk of that kind of injury, which is fairly typical and fairly characteristic of most state laws and institutional policies. But again, calibrating that is going to be important. Next slide. There are three key obligations that colleges and universities have under the Stop Campus Hazing Act. The first of these is statistical reporting. And just by way of background, the Clery Act requires that every college or university each October 1 publish an annual security report, and it contains information on crime statistics reported to have occurred within the geography that the Clery Act covers, impacting that campus community. What this legislation does is add hazing to the list of crimes and other offenses that need to be included in this statistical report. So institutions should be capturing that information now. This will first be due to be included in the annual security report that is due, we believe, on October 1st of 2026. There is an argument that it's not required until 2027 due to some clumsy language in the statute itself. Presumably the Education Department, the U.S. Education Department, will provide guidance on this, but institutions should be gearing up to collect this information so that they can report it in the ASR that's due on October 1st, 2026. That will include information on crimes that occurred during calendar 25, which is, again, why we need to be capturing this information currently. Next slide. Second obligation under the Act is policy development. You'll recall I stated at the outset that the Clery Act requires institutions to adopt particular policies and procedures with respect to a whole variety of behaviors and threats and responses to those situations. This act adds additional content for the required policies. Institutions need to develop or update policies about hazing that include at a minimum what the definition of hazing is. And again, flashback 2 minutes, that needs to be consistent with the definition in the act. How people can report hazing, a description of the processes used to investigate allegations, and then information on local, state, and tribal hazing laws that may impose criminal penalties for hazing. Schools also need to create and begin to offer hazing prevention and awareness programs. Again, institutions are doing a lot of this already. This is largely about calibrating what their current practices are with what the law requires in terms of the scope of what's considered hazing. This has an accelerated due date. These policies and these programs need to be adopted and implemented and put into place by June 23rd of this year. Why June 23rd? Because the law says it has to happen 6 months after the law took effect. They then get published in the annual security report in either 2026 or 2027, depending on how the ambiguity I mentioned a moment ago is resolved. Kathy, next slide, please. And then finally, the third obligation under the Act is significantly different than what schools have to do under the existing provisions of the Clery Act. This is a fairly real-time website publication to be known as the Campus Hazing Transparency Report. Institutions need to do this starting on December 23rd of this year. Again, that's 1 year after the legislation became effective. And what this entails is starting then and then updated every 6 months, a report on the college or university's website that describes information about hazing cases that have been adjudicated through the school's conduct process. So institutions are going to be required to publish the name of the student organization found responsible for hazing, a description of the behavior in question, sanctions that were imposed, and then the dates on which the incident occurred, when the investigation was initiated, when the organization was found responsible for the hazing violation. This report is also going to have more general information about policies, applicable laws, and the availability of statistics in the ASR about hazing. But the game changer here is that institutions will be required to disclose, without identifying individual students, by name, which organizations on campuses have been found responsible for hazing. Why? Presumably so that students and their families can make informed decisions, not only as to whether they attend the institution, but also which organizations they become members of. So I am at my time at this point. If folks have questions, happy to respond to those offline, but I will turn it back over to Gabe at this point.
Bill, thank you so much. And as well, thank you for clarifying that we're dealing here with enacted legislation and the various elements of the ramp up that you covered. I'm sure you'll be back to cover more of the implications as they unfurl. And thank you so much for your time. Let's bring Jessica Copeland on next. Jessica is with us from our Buffalo office, a regular on the webinar. Jessica leads our cybersecurity and data privacy practice. I have the pleasure of working with Jessica regularly, and Jessica's here to discuss fairness implications in AI model training. Jessica, please go ahead. Thank you again for coming back.
Thank you, Gabe, and thanks for the time today. So there's so many topics that we can pick to discuss when it comes to artificial intelligence. And one very evolving area right now is the intersection of copyright law and use of AI. Kathy, if you could flip to the next slide, please. So full disclosure, I recently wrote a case summary on the decision in the Thomson Reuters versus Roth Intelligence case, which is the first case in the US that has resolved the question of whether training an AI model with copyrighted material is considered a fair use, which is fair use is a defense to copyright infringement. It doesn't mean that you aren't infringing. It just means that you might not be liable for the infringement because you have a viable defense. And when your AI model is trained on information that is protected by copyright, the question of whether that training for the purposes that your company is using it for, and considering what the output looks like and what the customers are using it for, would qualify as fair use. In the District of Delaware decision, it's fairly groundbreaking. The court decided that no, the AI model company that used Thomson Reuters head notes was infringing that copyright, and that infringement is not a fair use. So I'm getting a little bit ahead of myself. I get excited when I talk about AI. I apologize. But my disclaimer is that I asked Copilot, an AI tool that is integrated into Microsoft, to generate slides based on what I wrote in a Word document. And what you're looking at right now is the first slide. That is the cover slide for the 15 slides that are generated. So we're going to talk about the landmark case that I just mentioned, Thomson Reuters versus Ross Intelligence, and we're going to explore how artificial intelligence and copyright law intersect. We'll also talk about some of the takeaways that you can have. Next slide. So we'll go through a brief introduction, some procedural background of the case, and then Ross Intelligence's use of Westlaw head notes. So Thomson Reuters is the company that owns Westlaw. Anyone familiar with the legal research tool Westlaw? I'm sure you've used the head notes before. And then we'll go through takeaways. Next slide. So in the introduction section, we really want to just provide an overview of the Thomson Reuters case and highlight why it's so important in the landscape of AI and copyright law. So it revolves around Ross Intelligence, which is a legal research tool. And it decided that the head notes in many cases by Thomson Reuters were helpful summaries of case decisions. And in the copyright litigation, Thomson Reuters took the position that use of those head notes was an infringement of its protected information. And if you actually look at I think it's like a 30-page decision, the complaint had to itemize which head notes it was referring to. And there are thousands of head notes at issue in the case, almost 10,000, I believe. And this particular decision only relates to 2,200 of them. So there are many issues underlying the court's decision, and several issues, frankly, that will go to trial because they were not resolved and motion to dismiss or summary judgment posture. But in any event, so one of the defenses that Ross used was, well, these head notes are just a reflection of what the court decision is, and the court decision itself is not a copyrightable data point. So then the court said, well, the fact that Thomson Reuters took certain quotes from a decision, which by the decision by itself is not copyrightable, but the Thomson Reuters attorneys that work there and pull out key facts of the case are creating those head notes. And that is potentially copyrightable information. And I say potentially because in this decision that issued February 11th, the true focus was whether use of that information was fair use, not necessarily whether the actual each of those head notes was copyrightable. So that's still an issue that may go to trial if the parties don't settle. Next slide. So the importance of AI and copyright law. This is only one case, and importantly, this case it commenced, I believe, in 2019, pre-generative AI. Post-generative AI, there have been several litigations started across the country in New York, California, everywhere in between, in federal courts by content creators against AI companies. The most prominent is probably the New York Times versus OpenAI case, which is pending in the Southern District of New York. And in each of those cases, these questions are arising and not getting resolved. Whether or not this decision will impact that, I think is clearly a yes. I don't see this decision as complete and clean foreshadowing. It's certainly not precedent. This is a district court in Delaware. A district court in New York may decide completely different. So we'll really have to keep track of where the courts are coming out in order to help our clients navigate these issues. But it's certainly something, a decision that is going to be the focus of many AI companies that are building their systems, building their profit margin on the consumption of content that may be copywritten. So we could skip 2 slides. So as I mentioned, the court ruled in favor of Thomson Reuters and determined that Ross's use of headnotes to train its model did constitute copyright infringement, and it was not a fair use. And when the court reached that decision, the reasons that fed into that result are based on how Ross Intelligence was promoting the use of its legal research tool. So when you use Westlaw, you're conducting legal research and you're reading headnotes to make decisions and draft your own briefs as a lawyer. Well, Ross Intelligence use of the headnotes and the creation of the output was the same way. And they're in direct competition with what Thomson Reuters is doing. So that certainly played a factor in the court's analysis and determination as to whether it was indeed a fair use. It certainly highlights the fact that litigants, as well as content creators and AI companies, need to be mindful of where courts may lean in this regard. We're in a new world with artificial intelligence, as many of you know, and so there are not clearly defined guidelines in terms of what is or is not a fair use. All we know is this one decision, which we can, again, use as an education point, but it's not necessarily going to be so broad as to apply to every single instance of a copyright infringement case against an AI tool. Next slide. And we can keep going. As a side note, I do think that Copilot created quite nice slides for us to look at today. The content was okay. We could probably have modified it a bit to dig into it a little deeper, but I'm rather impressed. So we talked about the incorporation of the head notes, and we could skip up to the takeaways. Kathy, we're running out of time. All right, so the copyright implications, understanding what those copyright implications are is really the bulk of what you need to know as you read through the Thomson Reuters decision. And frankly, there are ways that companies even now are trying to navigate this cross-section, potentially trying to negotiate a license to use certain content in order to train models. I've seen that occurring just because there is not a clearly defined law and the lines are so gray at this point in time. It would almost be safer to sort of control your destiny and see what you can do to negotiate a reasonable licensing rate, depending on what your business model is built on. But that's certainly something to keep in mind because, as I mentioned, there are so many cases pending currently that we won't have any clear definition of what is and is not fair use for quite some time now. And I see that my time is up. If you have any questions, please feel free to reach out directly to me, jcopeland@bsk.com.
Fantastic. Thank you so much, Jessica. Really fascinating stuff. And I agree, the slides were pretty tidy, especially given how they came together through this new and powerful tool. We'll have you back on for more, I'm sure, as the year progresses. And in the interim, let me turn to our next speaker, who's Lauren Schnitzer. Lauren is with us from our Melville office, works in our school law practice, and she has been on the webinar previously, and this time we'll be covering Federal Health and Human Services, the department's release of guidance on new sex-based definitions. This will be a quick presentation just to give you all an introduction, and Lauren and others will be back to cover this as the implications continue to unfurl. But Lauren, please go right ahead. We're really glad to have you on.
Thank you so much. We can go to the first slide. So around February 19th, 2025, pretty recently, the Office on Women's Health, which is a part of the United States Department of Health and Human Services, released guidance in response to this January 20th, 2025 executive order that was issued. The executive order is called Defending Women from Gender Ideology, Extremism, and Restoring Biological Truth to the Federal Government. And we'll discuss in a few slides that this order required the Department of Health and Human Services to issue new guidance regarding sex-based terminology in compliance with this executive order. And this order provided that the administration is going to develop policies recognizing that women are biologically female and men are biologically male. Next slide. The executive order provides that it is the policy now of the United States to recognize two sexes, male and female, and that they are not changeable. And that the executive branch is going to be enforcing any sex protective laws to promote this interpretation of just two sexes. Next slide, please. And the executive order does contain some definitions, and the Health and Human Services website, which we'll get to in a moment, very slightly changed these definitions. They define sex in the executive order as an individual's biological classification as either male or female, noting that sex is not synonymous with the term or the concept of gender identity. Next slide, please. Gender ideology, because that term is used in the caption of the order, is defined in the order, and it discusses how gender ideology is internally inconsistent and diminishes sex as an identifiable or useful category, and maintains that it is possible for someone to be born in the wrong sexed body. And it discusses that gender ideology is an ever-shifting concept of self-assessed gender identity. Next slide, please. Gender identity is also defined in the executive order as a fully internal and subjective sense of self. And it provides that gender identity, according to the order, does not provide a meaningful basis for identification, and that it cannot be recognized as a replacement for a person's sex. Next slide, please. So around February 19th, 2025, consistent with the directives that were within the January 20th executive order, the federal website Protecting Women and Children was added to the Office on Women's Health, and there's a link here. That website had always existed, the Office on Women's Health, and there is now a new website within that site that is called Protecting Women and Children. Next slide. And within that new website, there are definitions in compliance with the order regarding sex-based terms. Next slide, please. Next slide. I know we're cutting close for timing. So these are the new definitions that are in the federal website, very similar to the definitions that are in the executive order. A female is a person with sex characteristics, being able to produce eggs. Male is a person with characteristics of being able to produce sperm. They added new definitions for mother as a female parent and father for a male parent. It's unclear at this time how these new definitions for the department are going to be applied. For example, how they will be applied in the healthcare industry, labor and employment, in education, in our schools. But we did think it was important to be updated and informed about how the various federal agencies are enforcing this gender ideology executive order, and to make sure that we're kept informed going forward, and we'll continue to monitor these changes and bring it forward to everyone. And if you do have any questions, please feel free to reach out.
Lauren, thank you so much. Yes, with 5 minutes, not enough time to get deeply into these issues, but I agree. We just wanted to make sure that the audience was introduced to the fact that there are changes afoot at the federal level that may well be relevant, and we'll continue to unpack those implications. Our last speaker for the afternoon will be Mario Ayub. Mario has been on our program many times over, sits in Buffalo and works out of our cybersecurity and data privacy practice and wears a few more hats in addition to that. I've had the pleasure of working regularly with Mario, and he is here today to address parental consent requirements for online education services. Mario, thank you so much. The floor is yours.
Thanks, Gabe, and thanks everyone for spending your lunch hour with us. So before you tune me out, if you're not in the education sector, there's plenty of stuff here that will apply to other industries as well, especially for those who operate websites that offer services through those websites. So this is not just for educational purposes, but this is the lens that we're going to look at it today. Next slide, please. So just a quick rundown of what I hope to cover in the next couple minutes or so. We're going to take a look at a Google Workspace requirement that is now in effect as of this March, as a sort of lens to look at some of these parent and guardian consent requirements, and then some practical recommendations for complying down the road. Next slide, please. So very quickly, a lot of clients have been reaching out regarding a new requirement to obtain parental consent for additional Google services. So for those who might not be familiar with Google's education offerings, they provide core services to schools across the country that give you access to your basic Google apps for educational purposes. Additional services, including more media-rich content, YouTube, maps, photos, those are categorized as additional services and outside of Google's core offering. And as of March 2025, schools that would like to bring access to these additional services to their students need parental guidance to access those. So what's the impetus for this? Google doesn't really explain. To get to the answer, let's take a look at some of the laws that are influencing Google's decision here to require this consent. Next slide, please. So first up, we have the Family Educational Rights and Privacy Act. This governs the safety and security of student education records generally. Student educational records is pretty broadly defined here, and it can include a lot of different elements and a lot of different metrics based on student academic performance, demographic information, things like that. And written consent is required from parents and students under the age of 18 before releasing information to third parties. So there's one area in federal law where parental consent is required. Next slide, please. In New York, we have something very similar that mirrors a lot of FERPA's consent requirements, and that's Education Law 2D. Again, this is a regulation designed at protecting student data, preventing unauthorized release. And it also requires a verifiable parental consent before disclosing information to third parties that are outside of the education context for which the school is working with that vendor. So if it's in line with a contract to provide educational services and there's additional safeguards in place, it might not be needed. But if you're going to offer access to additional services, just like we saw in the Google's case, to things that have less of an obvious academic application, you need consent. And then next slide, please. Finally, COPPA, and this is the law that's going to apply broadly, even outside of the educational context. I'm not going to be able to get into too much detail on the requirements here, but again, verifiable parental consent needs to be obtained before you can collect information from children online. So this applies to any type of industry, any service that's marketed online where a minor might have access to it. That's where this is coming from. So FTC released a little bit of guidance on it in the educational context, and the verification requirement, the parental consent requirement, it does not necessarily apply if the service that's going to be provided or the vendor engaged is going to be doing it for educational purposes. But it's really unclear, based on the guidance from the FTC, how some of Google's additional services would be categorized. YouTube obviously has a fair amount of educational applications, but that there is a ton of marketing activity on there, data collection that's outside that realm of education. The FTC doesn't really provide much here. So education institutions should take a conservative approach, make sure that their parental consent structure mirrors what COPPA requires. Next slide, please. And finally, some quick recommendations to keep in mind as you're navigating this space. Examine your existing practices. So like I said, it often comes up in educational settings, but if you're a business that markets services, provides online accounts to access services that could be accessed by minors or even intended to be accessed by minors, make sure you have the mechanisms to collect parental consent that you can verify was from the parent. And we provide guidance to clients all the time about how to set up these mechanisms depending on your business or in the practices you have online. Second, parent guardian consent. Take a look at all of the laws that we just talked about, including other maybe more state-specific laws if you're looking outside New York, to make sure the format that you're collecting this consent aligns with your legal requirements. And finally, a data protection agreement. This is definitely something that's required in the education space, certainly required under Ed Law 2D, but anywhere that you are contracting with a vendor or a third party to process data, especially where that implicates a minor, make sure you define the parameters of what's allowable and what's not in a separate data protection agreement so that you make sure the minor's data stays safe and is not subject to further disclosures. So a lot of information all at once. I'm available offline to take any questions. Next slide, please. Oh, so that's Gabe's email, but my email is mayoub@bsk.com. Feel free to reach out anytime. Thanks, Gabe.
Mario, thank you. And I know that you're available if anyone has questions. Kathy, if you would go to the next slide, please. There are the email addresses for all of today's presenters. We are really glad that you took your lunch hour with us. Next week, I won't be with you as host, but I will be back on the 18th. I look forward to seeing you then. And please, everybody, tune in on the 11th if you do have that time available. Carrie will be leading that program. In the interim, wishing you all a great balance of the week and a good start to March. Thank you again for your loyalty to the program.